My name's Alex Craig, I'm a partner at Muckle LLP and I've been asked to talk to you today about IP, data and tech in a post-Brexit environment. So thank you very much for listening. We're still very unclear what's going to happen this month, and it's important to understand what you should consider at this stage. I definitely don't have all of the answers, but I've pulled together this session from what's currently available from the government. We have about an hour and a half or so. I'm going to run through everything, and if you have any questions at the end, then you can refer to the chamber. So, without further ado, the first thing I'm going to look at is data protection and specifically GDPR. So GDPR was implemented on the 25th of May 2018. We've all been and still are working towards compliance in our organisations, reviewing our data flows, mapping them, putting in place compliance, privacy policies, notices, training our staff, negotiating data processing or sharing agreements and applying model clauses. And you may be thinking to yourself, after all of that hard work, what is the position going to be after Brexit? Has it actually all been worthwhile? So will the GDPR still apply in the event of a no-deal Brexit? The situation is this: if the UK leaves the EU without a deal, existing arrangements on the flow of data would no longer apply in current form. The government's put in place legislation to ensure that there would be no immediate change to the UK's data protection standards and has taken action to allow the free flow of personal data from the UK to the EEA, remembering that the EEA is the EU plus Iceland, Norway and Liechtenstein. But what's also going to happen is that the EU Withdrawal Act will retain the GDPR in the UK legal system, and it gives the government the power to make amendments to ensure that it works effectively in the context of the UK legislation. The government's going to use these powers to make the necessary amendments to the GDPR and other data protection prior to exit day. And the vast majority of those changes will actually just be removing references to EU institutions and procedures that won't obviously apply when the UK is outside of the EU. You may say to me, well, what about the Data Protection Act 2018? What's that all about? Why is that legislation already in place? So basically, the GDPR has direct effect across all EU member states and has already been passed. So organisations still have to comply with this regulation, and we still have to look to the GDPR for most legal obligations in relation to data protection. But the GDPR gives member states limited opportunity to make provision for how it applies in their country. And one element of the DPA 2018 details these. So you have to read the two pieces of legislation side by side. So by way of example, the DPA 2018 covers processing that doesn't fall within EU law, for example, in relation to immigration. It also covers processing of personal data for criminal law enforcement purposes, national security, and it also specifically provides parts to cover the ICO and its duties, functions and powers, and repeals the previous data protection legislation. The critical thing to note in all of this, of course, is that if we leave, which is anticipated, the UK will, regardless of whether or not there's a deal, become a third country, and transfers of data to it will need to be legitimised. So the UK is ideally looking for an adequacy decision. And the UK is pressing the European Commission for an adequacy decision. But what is one of those, you may say? Well, essentially, the European Commission has a legal framework which enables it to identify whether a country has adequate protection for individuals' rights and freedoms for their personal data. So this is the EU's central legal mechanism for enabling the transfer of personal data from the EEA to non-EEA countries. So from our point of view, we think, well, we comply with GDPR, we have the Data Protection Act 2018, all we need is an adequacy decision, and then the data will still be able to flow to the UK as a third country, notwithstanding we're not part of the EU. Unfortunately, it's not as simple as that. First of all, the Commission has been absolutely 100% clear that it is not planning to adopt an adequacy decision in relation to the UK at the point of exit. despite us pressing. And equally, these things are unfortunately not very fast. So the fastest adequacy decision that's been taken by the Commission took 18 months. So we simply can't say, well, let's not worry about it, there will be an adequacy decision. We need to look at other safeguards in order to get data flowing freely to the UK once it's left the EU. Okay, so what does that mean in the meantime? Well, we need to be prepared and we need to consider the different scenarios in terms of data flowing across the EU. There are 4 essential possible scenarios. UK businesses and organisations who have no contacts or customers in Europe, UK businesses and organisations who send or receive data to or from Europe, UK businesses and organisations with a European presence or European customers, and UK businesses and organisations who send or receive data to or from countries outside of Europe. We're going to look at each of those in turn now. So for UK businesses and organisations who have no contacts or customers in Europe, what do you need to think about in terms of data protection? Not very much. As long as you are complying with GDPR now, you're in a very good place. The UK has stated its commitment to maintaining high standards of GDPR, and government plans to incorporate it into UK law alongside the Data Protection Act, as we've discussed. So all you really need to do is continue on your compliance journey, adhering to the legislation, and make sure you review your privacy information and documentation to identify any minor changes that might need to be made, for example, referencing EU. What about those UK businesses and organisations who do send or receive data to or from Europe? Again, compliance with GDPR now is critical. And again, the UK is committed to maintaining those high standards of GDPR. UK businesses will be covered by the UK data protection regime post-Brexit. And the UK government has been clear that transfers to the EEA from the UK will not be restricted. So if you do that, you won't need to take any additional steps. However, if a business or organisation in the EEA is sending you personal data, i.e. into the UK, then it's still going to need to comply with EU data protection laws. You will need to take action so the data can continue to flow. And remembering that we don't think we're going to have an adequacy decision, what is your safeguard going to be? Well, in all likelihood, it's going to be putting in place standard contractual clauses, which is one of the safeguards that's been approved by the Commission. However, I have 2 comments on that. The first is, don't be too confused. They're available on the ICO website, but they refer to the old legislation. They've not been updated yet. So you may be worried that you've got the wrong thing. You haven't. They are still recognised and they are still applicable. You can still use them. The other point that I want to make on those is that you may have heard of a gentleman called Max Schrems, who is the person who has been and is challenging the transfer of data specifically to the US and the basis on which that transfer is made. So he is the person that resulted in the abolishment of the safe harbour regime and the replacement of that regime by the Privacy Shield. Well, he's currently having a go at both the Privacy Shield and standard contractual clauses. So there is a risk that going forward, those standard contractual clauses may actually not be found to be adequate. But at the moment, they are, and that's what you need to have a look at. If standard contractual clauses aren't an option, then you need to look at some of the exemptions, and you'll probably need to take specific advice on that. UK businesses and organisations with a European presence or European customers have some additional things to think about. So again, compliance with GDPR is key, and we've already talked about how the UK intends to deal with GDPR post-Brexit. But if your organisation operates in the EEA, you will need to comply with both UK and EU data protection regulations. You will need to appoint a representative in the EEA. If you have offices, branches or other establishments in the EEA, your European activities will be covered by EU law even after Brexit. So you need to establish who your lead supervisory authority will be. Currently, we're in the EU, so your lead supervisory authority, if you're based in the UK, is likely to be the ICO. Post-Brexit, you will be governed by the UK data protection regime, so your supervisory authority in the UK will be the ICO still, but in relation to your EU activity, you will need to nominate and identify a lead supervisory authority there. So you're going to end up with two. If you're only based in the UK but you offer goods or services to individuals in the EEA or monitor their behaviour, you will still need to comply with EU data protection regime. Again, you're going to need to appoint a representative in the EEA. That person will act as your local representative with individuals and data protection authorities, and you'll need to find a provider who offers those services. You will have to have a written mandate in place with that organisation, and you'll have to be clear to your data subjects who that party is and who they are in terms of the supervisory authority that applies to you. My little observation on that particular section is that you may think, fine, no problem, we'll get that sorted out. And indeed, that should be the case, but you may find it slightly tricky to find someone who will act as your EU representative, simply as the regime is so new. There aren't very many organisations who offer this service, so be prepared to undertake a bit of searching. Again, as before, for the previous scenarios, you will also need to have a look at your privacy information and documentation to identify any minor changes that need to be made after Brexit. The fourth scenario is UK businesses and organisations who send or receive data to or from countries outside of Europe. Basically, the rules for sharing data with countries outside of the EEA will remain similar. At this stage, you don't really need to take any extra steps. The UK government has confirmed that there will be transitional provisions to recognise existing EU adequacy decisions that are already in place and EU-approved transfer safeguards. So your best preparation here is, again, comply with GDPR, review your documentation and keep everybody up to date. The ICO has published on its website various pieces of Brexit relevant advice, and in particular it has set out 6 steps in terms of what you need to think about before Brexit happens from the data protection perspective. It's essentially a summary of what we've already talked about in this session. So first of all, you continue to comply with the GDPR and the Data Protection Act 2018, which will remain in place, and GDPR will be brought directly into UK law. You need to look at the situation where there's data transferring to the UK, review your data flows, identify where you receive data from the EEA, and think about safeguards that need to be put in place. There may not be an adequacy decision that you can rely on, so standard contractual clauses may be the solution. You need to think about transfers from the UK, review your flows again, identify where you transfer data to the EEA. The UK government, as we've said, has stated that when the UK exits the EU, transfers to the EEA from the UK will not be restricted, and rules on transfers to countries outside the EEA are likely to remain the same. In terms of European operations, as a UK organisation, you need to comply with UK data protection regime after exit, which will be regulated by the ICO. If you have offices, branches, other establishments in the EEA, the EU regime will still apply to your European activities even after the UK leaves. The ICO will not regulate the EU regime. Check your documentation, identify references to EU law or other EU terminology, and be ready to make changes. Review what you say about international transfers and reflect any changes you are making. And obviously, one of the requirements under the data protection regime is to make sure that you have organisational awareness at all levels. So you're probably going to have to train your staff further if you are making changes across your organisation. In summary, ensure compliance with GDPR and be aware of changes that you may need to make if you control or process data across the EU. My final point on data protection before we move on is to say that transferring data is not the same as data in transit. If personal data is just electronically routed through a non-EEA country, but the transfer is actually from one EEA country to another EEA country, then it is not a restricted transfer. Personal data that is transferred from a controller in France to a controller in Ireland, by way of example, both in the EEA, via a server in Australia, in that situation, there is no intention that the personal data will be accessed or manipulated whilst in Australia, so therefore the actual transfer is only to Ireland. It is important that you distinguish between transfer and transit. That's the end of the section on data protection. I'm now going to talk about intellectual property. So, before I start, for those of you who are not familiar with intellectual property, there are various different types of protection available for what are essentially intangible rights. Without going into the detail of each of those rights, they are essentially trademarks which protect things like names, brands, logos, jingles, colours, strap lines, and essentially distinguish the goods and services of one business of those of another. There are registered designs which protect the appearance of a product, so the lines, contours, shapes of a particular product. There are patents which protect the clever stuff, the inventions, the really novel new ways of doing things. And there are some rights that are not registrable. They arise automatically on creation, and they include copyright, which protects artistic, literary, dramatic and musical works, including computer code for reference. And also we have the design right, the unregistered design right, which protects the shape and configuration of a particular item. All of these things I'll run through in terms of the impact of Brexit on them. From a trademark perspective, the existing UK system for protecting trademark rights will largely remain unaffected by the UK's decision to leave the EU. But there are different processes for registering trademarks. There is the national system, there is the EU system, and there's an international system. While the UK remains a full member of the EU, EU trademarks continue to be valid in the UK. When the UK leaves the EU, in any situation, deal or no deal, an EU trademark will continue to be valid in the remaining EU member states, and UK businesses will still be able to register an EU trademark, which will still cover all remaining EU member states. But for existing EU trademarks, the government is very keen to ensure continuity of protection and avoid loss of rights, because obviously in relation to the UK, it will no longer be a member state, so what does that mean for that protection? The government's outlined its plans. Essentially, the plan is this. The IPO on exit will create comparable UK trademarks, which will be recorded on the UK Trademark Register. These comparable UK rights will retain the filing dates recorded against the corresponding EU trademark, and will also inherit priority or seniority dates from that EU trademark. There is no cost for this. They will become fully independent UK trademarks, which can be challenged, assigned, licensed or renewed separately from the original EU trademark. Usual UK fees will apply thereafter, and a new number system will be put into place. So essentially the 8 digits from the EU trademark will be taken and prefixed with a 9, so you will always be able to identify that that particular UK trademark originally was generated from an EU trademark. That will happen on exit. It is possible to opt out of this process, but I'm unclear why anyone would want to do that. After exit, in relation to organisations who actually have EU trademark applications which are ongoing at the date of exit, you will be able to refile those applications with the Intellectual Property Office in the UK under the same terms. But in order to benefit from the original filing date, you will need to do that within a 9-month window of exit, using the usual application process for registered trademarks in the UK. The usual process is available via the UK IPO website, online or by post. You do need to remember that 9-month period. The government will recognise filing dates and claims to priority and seniority recorded on corresponding EU applications, but only within that 9-month period. Thereafter, you won't be able to get that benefit. You will also incur a fee. I accept this does seem slightly harsh, but it's the reality of the situation. In terms of international trademark filing, slightly confusingly, we do refer to international trademarks, but they are not truly international. Essentially, we have what's called the Madrid system, which various countries have actually signed up to, which enables you to file one trademark application and then identify the countries in which you want that trademark to be protected by national designation. This Madrid system allows one application in one language and to pay one set of fees in up to 113 territories, including the EU. UK businesses will continue to have access to the Madrid system when they're looking to protect their trademarks post-Brexit. You will be able to designate the EU and equally the UK in that process. Lastly, just to mention on trademarks, in terms of the geographic indication regime, which is the system which is available to indicate that a product has specific geographical location or origin and acts as a certification that the product possesses qualities or reputation or is made according to traditional methods that are due to that origin, you need to understand that there may be some changes. For example, locally, there are geographic indications for the likes of Cumberland sausage and Lakeland Herdwick, and there are various other products across the UK that have equivalent protection. UK produced food or drink products with geographical indication will automatically be transferred onto new UK GI schemes after Brexit and remain protected in the UK. This system will mirror the EU scheme and fulfil UK World Trade Organization obligations. In a no-deal scenario, it is possible that the EU may not continue to protect UK GI products. Hopefully this will become clearer. However, you should be prepared if you have such a geographic indication that you may need to apply to the European Commission to regain EU protection and the right to use the EU geographic indication logo. So moving on to registered community design, as I said earlier, the community designs protect the appearance, so the decoration or lines, contours, shape of a particular product. If you remember those children's suitcases that they tend to run people over with in airports called trunky, or there are various variations of those, they are something that are protected by way of registered community design. So that'll give you an idea of the sort of thing it might protect. So this is very similar to trademarks actually. So you've got the basic situation where the UK remains a full member of the EU and registered community designs continue to be valid in the UK. When the UK leaves, then the registered community design will obviously cover the remaining EU member states. The government's clarified exactly the same as in relation to trademarks, that it's wanting to preserve protection and minimise administrative burden to those with registered community designs. And so essentially the same thing as for trademarks will happen. There will be a new UK equivalent right granted that will come into force at the point of the UK's exit from the EU. The new UK right will be provided, and the design will then be treated as if it had been applied for and registered under UK law. Again, there'll be a specific numbering system in place so that you can identify those community designs to which it applies. And again, these designs will be subject to renewal in the UK thereafter and will form the basis of proceedings before the UK courts and the Intellectual Property Office's Tribunal, and can be assigned and licensed independently from the EU right. As for trademarks also, after exit, if you have a community design application which is ongoing at the date of exit, you'll be able to refile with the Intellectual Property Office under the same terms for a UK equivalent right using the same process as exists currently in the UK. And again, exactly the same as trademarks, there'll be a 9-month window during which the government will recognise filing dates and claims to earlier priority and UK seniority recorded. You will have to take that step though, and you need to remember that you might need to do that. Equally, once the UK leaves the EU, UK businesses will still be able to register a community design, which will cover all remaining EU member states. Just to mention the Hague Agreement in relation to international designs, the government's ratified the Hague Agreement and has joined this international system in its own national capacity rather than through the EU. So the Hague system for international registration of industrial designs, which allows for registration of up to 100 designs in over 68 territories through one single international application, will still be available to UK business post-Brexit. Better news in relation to patents. So if you remember, these are the clever things, so the inventions, the novel and new ideas of how to do things or how to make things. So because the European system for patenting has actually got nothing to do with the EU whatsoever, there will be no change, you will be pleased to hear. So there is no immediate action required with respect to European patent law or patent litigation. Existing European patent rights remain unaffected for the time being, and UK business can continue to apply to the European Patent Office for patent protection, which will include the UK. Unregistered community design. This, in my view, is slightly more complicated because we have an unregistered design right in the UK and we have an unregistered community design. They are slightly different to each other. And whether or not this applies to you, you will have to decide. In my experience, there are fewer businesses who tend to have designs as opposed to, for example, trademarks. But so that you're clear, while the UK remains a member of the EU, designs, including, for example, clothing and designs and patents, can be automatically protected in the EU as unregistered community designs. This gives a design 3 years protection from copying. Designs that are protected in the UK as unregistered community designs prior to exit will continue to be protected as what will be known as UK continuing unregistered design and will be automatically established on exit day. If you recall from what I said earlier, these rights arise automatically and aren't registrable. The UK will continue to provide unregistered community designs with protection in the UK for the remainder of the 3-year term. Once the UK leaves the EU, unregistered protection for designs will continue through the UK Unregistered Design Right, which provides a longer term of protection for a different scope of design features. So in the UK, the system provides that the protection lasts for 15 years or 10 years, depending on when it was first put to market. In addition to all of this, where the UK does not have existing domestic legislation to protect certain types of rights, it will establish new schemes which will preserve the full scope of the unregistered community design right in the UK. This is, as I said before, because there is a difference between the two regimes. The unregistered community design right is different to the UK right insofar as it provides the same protection as a registered community design, whereas within the UK, the registered right protects designs in terms of their lines, shapes, contours, as I've already explained. An unregistered design right protects the shape or configuration of an item. This distinction doesn't apply within the EU. So because there's a variance between the two, the UK is creating a UK unregistered design right called a supplementary unregistered design. The introduction of this right will ensure that the full range of design protection provided in the UK prior to exit will remain available after we leave the EU. The terms of the supplementary unregistered design will be similar to that already conferred by the unregistered community design, but the protection will not extend to the EU. The supplementary unregistered design will mirror the unregistered community design by providing post-exit UK protection for designs that would have otherwise enjoyed protection under the unregistered community design. As I said, in my view, this is relatively complex, and I think it's important that businesses take specialist advice on this if they think it applies to them. Moving on to copyright. Again, you might consider that intellectual property rights is a relatively straightforward area in light of what I've already explained. in light of the changes that are anticipated in relation to intellectual property rights due to Brexit. Copyright, in my view, is also, however, complex. Copyright, as I said before, protects artistic, musical, literary, dramatic works, so sound recordings, broadcast films, typographical arrangements, computer code. The primary legislation within the UK on copyright is the Copyright Designs and Patents Act 1988. There's also a body of secondary legislation on copyright. Some of these regulations have implemented EU directives on copyright, and these directives go beyond the international treaties in place to further harmonise copyright law within the EU and remove barriers to cross-border access to copyright content. In all of this, you need to remember the basic principles of EU operation and the 4 pillars, the basic requirement for free movement of goods, services, capital and finance, and all of those principles flow into the legislation and how they operate. So when I'm saying these directives go beyond the international treaties to harmonise copyright law, it's basically to ensure that all of that free movement still happens. But obviously we won't be in the EU anymore. The UK's implementation of the EU directives in relation to copyright has resulted in several references in UK legislation to the EU, the EEA and member states. There are also 2 EU regulations which have direct effect on copyright and related rights. These apply directly across all member states. The regulations provide for cross-border portability of online content services, like video on demand, and the import and export of accessible format copies of copyright works, for example, Braille copies of books, respectively. To ensure UK copyright law functions properly if the UK leaves the EU without a deal, the government is going to introduce a specific piece of legislation which will remove or correct references to the EU, EEA or member states in UK copyright legislation and preserve the effect of UK law where possible. The UK is a member of a number of international treaties and agreements protecting copyright, and the majority of UK copyright works are protected around the world. This will continue to be the case following exit from the EU. When we leave the EU, certain cross-border copyright mechanisms will not, however, work in the same way as they're currently intended. I'm not going to go further into copyright today because I think it is, again, an area where if you are concerned about copyright in relation to your business and how you operate, if, for example, you're aware that there's a specific piece of legislation on copyright that affects you, then I strongly recommend you take specialist advice and you interrogate the changes that are anticipated and what you may need to do. By way of example, there is what's called the database right, which were introduced by the Database Directive and provide database owners with the right to prevent the unauthorised copying of or extraction of data from their databases. These databases involve substantial investment in terms of time, money or effort and were created by an EEA national resident or business and receive automatic protection in all EEA member states. The UK has implemented this directive via the Copyright and Rights in Databases Regulations 97. But obviously there will be some changes as a result of departure from the EU. UK citizens, residents and businesses will no longer be eligible to receive or hold those Sui Generis database rights in the EEA. UK database owners may find that their rights are unenforceable in the EEA and should consider whether they can rely on alternative means of protection, for example copyright. UK legislation will be amended so that only UK citizens, residents and businesses are eligible for new database rights in the UK after Brexit. That said, database rights that exist in the UK prior to exit will continue to exist in the UK for the remainder of their duration, which is 15 years in total. Those in the UK who wish to use databases protected by these rights will continue to need the permission of the right holder. So, now that we have considered the intellectual property rights, we're going to have a quick look at international trade because your IP rights may be affected. So there is a principle which is known as the exhaustion of rights, which again goes to the very basic premise of how the European Union operates and those 4 pillars that I talked about earlier. The exhaustion of rights principle essentially means that after the first sale of a genuine product in which there are IP rights, the IP owner can control the further resale of the genuine product. The exhaustion of IP rights occurs in the UK when an IP protected good is placed on the market anywhere in the EEA. It means that right holders may not prevent the movement of those goods within the EEA by relying on their IP rights. This is known as parallel trading and is different to counterfeit. So essentially, you need to consider whether you are going to be in a situation where you are going to be reselling goods that have been put on the market in the UK into the EEA, which are subject to IP protection. If you are going to have to speak to the IP rights holder to ensure that you have the necessary permissions to enable you to continue to do that post-Brexit. Essentially, in a no-deal situation, there may be restrictions on the parallel export of goods from the UK to the EEA. Goods placed on the UK market after the UK has exited the EU will not be considered exhausted in the EEA. I have two further points to raise in this session. The first is to mention the e-commerce directive. This governs online commerce in Europe, and it regulates certain legal aspects of information society services. What are they? They are services normally provided for remuneration, including indirect remuneration like advertising revenue, at a distance, by electronic means, at the individual request of a recipient of the service. Obviously, this covers the vast majority of online service providers like online retailers, video sharing sites, search tools, social media platforms, internet service providers. Again, it goes to the basic premise of the operation of the EU. The directive was introduced to promote e-commerce across EEA countries and remove barriers to trade by setting up a country of origin principle. Essentially, any EEA-based information society service is only subject to certain laws in the EEA state in which it is established. If there's no Brexit deal, immediately following the UK's exit from the EU, the government will continue to align with the directive. Information society services established in the UK will no longer be entitled to benefit from the country of origin principle when operating in EEA states, so they may be required to comply with rules in the coordinated field, i.e. the rules that govern online activities in each EEA state in which they operate. UK legislation will continue to apply to UK-based information society services when providing services to users in the UK. But when providing services in another EEA country, they will only have to comply with that country's requirements. The reciprocal country of origin principle for EEA-based information society services will be removed from UK legislation that implements the directive should the UK leave the EU without a deal when parliamentary time allows. Removing this principle from UK legislation will bring EEA-based information society services in scope of UK laws from which they were previously exempt, but obviously note the point about when parliamentary time allows. So what should you do in relation to the e-commerce directive? You need to consider determining your online service's place of establishment to understand whether you'll be impacted by the loss of the directive's country of origin principle. If you're established outside of the EEA for the purposes of the directive, you should check for compliance issues in any EEA countries in which you operate, resulting from the loss of the directive's country of origin principle. Build on your existing processes for ensuring compliance with legal requirements relating to online activity in each individual EEA country. Ensure that you have processes in place for ongoing compliance in the event that individual EEA states change their requirements governing online activities, and consider professional advice and support. Review the information you provide for users about your location, legal registration, terms of service, conditions of sale. Review what business you do in Europe, decide whether the amount of business you do in any given European member state might merit the creation of a representative presence there. Review the systems you have in place for your customers and users to notify you of content which may violate your terms of service of the law. Finally, domain names. This is not deal related, this is just a fact. The rules that govern the use of .eu domain name states that only persons, companies or organisations based in the EEA can register them for use. When the UK leaves the EU, over 340,000 UK users will lose their right to their .eu domain name. This happens whether there's a deal or not. On October the 24th, 2019, 1 week before the UK leaves the EU, domain registrars will begin notifying UK holders of .eu domains that will no longer be compliant with domain rules. Holders will wish to retain their .eu domains will then have until the 1st of January 2020 to update their contact data from an address in Britain to the address of a valid legal presence in any EU member state. At midnight on the 1st of January 2020, all .eu domains still registered to UK addresses will be immediately withdrawn. So what should you do? Review any services or processes run on .eu domains and prepare to migrate them to a new home. Inform your customers of your new domain and contact email addresses, and also check whether this creates any IP issues for you. Often, businesses' trademarks or business names are incorporated within their domain names. You may need to revisit your IP protection. That's the end of this webinar. I hope it's been of some help. If you have any questions, please contact the Chamber's Brexit helpline on 0845 226 0040.